Welcome to Colorado Criminal Defense with James Colgan.
From the Front Range to the courtroom, this is Colorado Criminal Defense with James Colgan. I'm your host, Lisa Mosby. When your freedom and reputation are on the line, experience is the only thing that matters. In each episode, we go behind the scenes of the justice system with James, a seasoned defense attorney dedicated to fighting for the accused across the state of Colorado. Whether you're facing charges or just want to understand your legal options, you're in the right place. Let's dive in, James. Are you ready?
Good morning, Lisa. How are you?
I am well. Why is the Hollywood version of trial so different from the daily reality of the Colorado legal system?
Well, that's a good question because, frankly, Hollywood doesn't have time to wait until you go from the beginning of the case till the end of the case. Things don't happen overnight. Good work requires hours and hours, some months, sometimes years of work before you get to the end result. Hollywood doesn't have time for that. And a lot of the work that myself and my team put into a case is frankly tedious work, but it's necessary. It takes a long time. Plus, there's a lot of bureaucratic red tape you have to go through with the court to get evidence that you want. I think, frankly, the best answer is probably Hollywood doesn't have time for the amount of work that you have to put into a case.
And I say that in jest, joking, because we all have this idea of what that whole trial experience might be in real life. And we often hear about the trial penalty. Can you explain how the risk of a much harsher sentence is? What is the risk after a trial loss influences a defendant's decision to settle early?
Well, I think it really enters into the picture quite often, to be honest, because even if a client feels as though they didn't do the crime that they're charged with, they're so afraid of the penalty of going to a trial, both put in by a jury and sometimes by a judge. There are judges that will see what a potential plea bargain was. The defendant may turn down that plea bargain because he doesn't feel that he did the crime, and then the judge will be even harsher. So sometimes that happens, but most of the time it is that the person has a very difficult time admitting to something that they truly believe they didn't do. And if they go to trial, the law is very harsh at trial. It can be very, very harsh. Mandatory sentencing provisions and those kind of things will cause a person to end up in prison for a lot longer than they envisioned just because of the law.
And how often does uncovering a smoking gun or realizing the prosecution's evidence is weak lead to a case being dismissed before it ever sees the courtroom?
5% of the time, maybe 5%. I mean, literally, if you hand me 100 cases, I can give you approximately 5 that I've had dismissed outside the presence of a jury.
So that's a small number that we're working with.
Extremely small number.
Yeah.
But Lisa, you got to remember that the standard to getting a case into the court system, into the judicial system, is pretty minimal. Probable cause, and probable cause basically is, I think it's very subjective. Certain people feel that though they have a case when another person with maybe more experience will look at it and say, you don't have a case at all. But there's these differing opinions. And the standard for prosecution, at least in the state of Colorado, is there a reasonable likelihood of conviction at trial? So when a case is being prosecuted, that's the standard that the prosecutor looks at. And again, we have differing opinions as to view. It goes from jurisdiction to jurisdiction, prosecutor to prosecutor, experienced versus inexperienced. Sometimes they all look at it through their own particular lens and say, I think I can prove this case. And another guy will look at it and say, I can't prove this case. To be honest, sometimes it's a roll of the dice. There are some jurisdictions you want to commit a particular crime in because they're somewhat lenient. There are other jurisdictions like, no, you're in big trouble if you commit that crime in that jurisdiction. So that's kind of how you have to look at that.
And oftentimes, prosecutors only file cases they're highly confident they can win. Does this selective charging create a system where the odds are inherently stacked against going to trial?
It's more so on the federal level where they basically have slam dunk cases and they only file slam dunk cases on the federal level. I do practice in federal court as well. On the state level, um, it's a little bit it's a little bit lessened, but for the most part, you're right. Prosecutors don't like to lose. You don't win elections when your office is losing trials. I mean, that's the simple politics of it. So they do like to, and you got to remember that at least compared to the average defendant, the prosecution has unlimited resources to prove cases. They have almost unlimited investigation. They have unlimited access to records that, frankly, the defense doesn't have access to. And with those unlimited resources, sometimes it can seem as though they're stacking the deck. Yeah.
And then can a well-timed motion to suppress evidence effectively end a case before the trial date's even set?
Most of the time, the courts don't deal with motions to suppress until the court date is set. But
Oh,
you're right. You can, with a very well-timed motion to suppress, and sometimes something called a bill of particulars, which makes the prosecution spell it out in black and white how they think they're going to prosecute and how they're going to convict your client. Sometimes that will nip it in the bud, so to speak. But yes, depending on the facts, of course, yes, a motion to suppress can stop the case before it ever gets to a jury.
let's talk about defendants. For many defendants in Colorado, waiting for trial means staying in jail because they can't afford the bail. How does the desire to get home to family or work pressure, it pressures people into maybe taking a plea deal?
Oh, Lisa, I can't tell you how many people I know for a fact have taken deals because of that exact reason. Because they're scared to death they're never going to see their family again, or they're scared to death that they're never going to get out of jail. And a plea bargain is daggled in front of them, and they say, "Yeah, I'll take it because I want to see my children, or I want to see my wife, or I want to see my parents. I want to get back to work because my kids are starving." I can't tell you that that doesn't enter into the picture. It does.
Yeah, and you mentioned it that trials are so resource intensive. And for a defendant, how does this factor into whether they decide to take their case to trial versus entering? I think you've already answered this question, but what I'm really looking for is, can you give us some specifics? Like, what have you seen? Maybe it disgusted you, or maybe, you were appalled by the pressure that this creates for the defendant.
Well, obviously, I can't give you specifics about the case. I can give you some generalities.
Please.
But yes, I have seen it happen on more than a few occasions where my client's in custody and we need to hire an expert in order to counter their expert. And we may not be able to get the funds together. So I'm required to use a football analogy, I'm required to call an audible and kind of change the play a little bit and maybe focus our attention not so much on the expert, but on some other thing because there's no money available. That has happened. Sometimes you can apply to the court asking for money, but if that's denied, you're going to have to play the cards that you've been dealt. And sometimes that does not include the expert that you would love to have. So, and if they're sitting in jail and they're not working, it's very hard to fund an expert when you're sitting there. And of course, depending on the case, depends on the amount of bond that's available to you. And it depends on the judge. Some judges are flexible and everything. You can go from everything to somebody charged with a serious crime that has no criminal history to somebody that's charged with a serious crime and maybe does have some criminal history. You would think that those people would be treated a little bit differently by the system. I can't say they are necessarily. So you've got somebody that is taking care of a family, something happens, a mistake happens, and all of a sudden it isn't just the defendant that's affected, it's the entire family. And sometimes they say, I'd rather feed my kids than get an expert. I've seen that happen.
So, how do you help the client weigh the safety of a certain result against the high stakes gamble of a trial?
Well, that's if a plea bargain is put on the table, I don't tell my clients what to do. What I do is I present options to my clients, and I pose those exact questions that you just asked and say, okay, here's how we go. We can take this to trial. We can't afford an expert, but here's how we can approach this defense. I think we can be successful approaching this. I'd rather have this expert, but we can't, so we've got to go this way. Or here's the plea bargain. This gives you a certainty in your life. If you take this plea bargain, you'll probably be out of prison in so many years. You'll be able to see your children in so many years. And it really depends on the client as to what's most important to them. Is it more important to me to admit to something that I may have not have done as long as I can see my children in a couple of years? Or is it more important for me to fight and say, I didn't do this and I'm not going to admit it? It really
It
depends.
really tugs at the heartstrings. Yeah.
No one ever taught me that in law school on how to deal with those issues. I'll tell you that much right now. That was not a course that I ever took in law school.
Yeah. In your experience, what are the red flags that tell you a plea offer is a bad deal? Are there any? I know you leave it primarily up to the client, but your experience has to like notice and be able to identify some of those red flags for the client.
Well, if it's inconsistent with things that I see in other jurisdictions with other colleagues, we talk. Defense attorneys talk all the time and say, okay, I have this situation. Here was the kind of plea bargain that I was offered. You do kind of a contrast and compare. Sometimes you do research out of a particular jurisdiction. When these kind of facts are presented, what kind of offers are being made? Because to be honest with you, well, I'm just going to say it up front. Sometimes I get concerned about the fact that race enters into the picture. And if I get an inkling that race is entering into the picture, for some reason my client is being treated differently than anybody else, I'll do research to see what is the consistent pattern from that jurisdiction. How are they treating those cases, and how are they treating my client's case? Because my job is to make sure that if at the minimum, my client is being treated the same as everybody else. Not different, not worse, but the same.
And you know what, James, I think we'll leave it there for today.
Okay.
And I just want to say thank you for tuning in to the Colorado Criminal Defense with James Colgan. For expert legal advice or to schedule a consultation, head over to jpcolganlaw.com. And don't forget to like, subscribe, and share this podcast with someone who may need it today. And we'll see you next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.